Welcome to the Supreme Court of the United Kingdom, where we are hearing remotely the appeal in the case of Henderson and Dorset Healthcare University NHS Foundation Trust. We are currently hearing submissions on behalf of the appellant presented by Mr. Nicholas Bowen, Queen's Counsel. And after he has completed his submissions, we will hear from Mr. Angus Moon, Queen's Counsel, on behalf of the respondents. In the meantime, I'll invite Mr. Bowen to resume his submissions.
You give me one moment, my lord. Could I just, before I get into Gray, make a short point on contributory negligence and then one fairly fundamental point on Patel, in addition to as an add-on to our previous exchange. Contributory negligence is a very important concept for you to consider, because denying a claim in its entirety for illegality is it's a very extreme, blunt tool to use. Contributory negligence, you will find, I'm afraid I don't have, it'll be given to me, I think, a reference in our case to a written case to a case called Revel and Newbury, where it was used. So there is certainly a basis in the books for you to look at that. That's expanded in our case. Contributory negligence as a concept is, of course, the fault or otherwise of the person without personal responsibility who is has, by reason of a tort, fallen into some form of unlawful conduct. Here, the killing is an objective standard. So having a gradation of personal responsibility, it's not an all or nothing concept, which is, of course, our entire case, fits, we say, in very well with the standard rules of tort, which is exactly why the Court of Appeal questioned at paragraph 49 of Gray, I won't turn it up, but you have it, that why is it needed that the traditional view of public policy contained in cases like Worrell and Clunis, and of course Gray, it needs to be looked at, so say the Court of Appeal, and we don't really see why the law of tort can't do it without the assistance of an all or nothing zero-sum game, which is of course what Sarah Green says. The Revel and Newbury reference, my lords, my lady, is EB 76 at footnote 20, and you will see the case itself in your bundle at tab 36, beginning at 1856 to 1869, but I won't turn it up. So in future cases such as this, if any indeed come along, contributory negligence can be used as a tool. It can't be used here because, of course, it's not been pleaded, there's a judgment, the point has been conceded. Turning quickly now to Patel, I plainly read you, in terms of certainly the exchanges at the beginning of my submission, that there is concerns that we can't simply ignore the element of responsibility that continues to exist by reason of the diminished responsibility plea. Well, that all goes in, I think I've probably already made this point, that already is factored into the three-stage test in Patel. The Patel test gives an ability to either deny it in its entirety or to allow it to some extent and then to look at the heads of loss. It's all achieved by Patel, but it's not achieved by Gray. Now, in terms of my note, I got to paragraph 94. We've had a look at it, and the rest of what I say on Clunis, it's all important material as far as we're concerned. It's answering a lot of what Mr. Moon says. So if there's anything specific, I'll pick it up by way of reply, but I'm going to read in all of that up to paragraph 100. That's clueness. Then we get to the approach to responsibility in grey. It'll take quite a long time to take you through all of the aspects of grey. So if I could I'm assuming that you will all be familiar with his distinction of the grey, of the narrow and the wide rule. The narrow rule being you can't claim for any of the consequences of the sentence. The wide rule being the aspect which gets rid of grief and future counselling, losses which are not related specifically to the sentence. I picked up specifically at 119 of the note, the theme that you can see. This is a quote from the Winegold case, but via the Hunter, via the High Court, the Apex Court in Australia. The theme through the cases I've referred to is where compensatory damage claim for the consequences of a criminal act are refused because the act was indeed criminal and the plaintiff was sane when committing it. So it's all about, and then you see the last line, human action could not probably be regarded as voluntary and is not the exercise of a free choice. Well, it's not covered by McNaughton, but it would be covered by our replacement concept. I then get back into the note properly at paragraph 120, that's page 31, where we get to what we see as probably the crucial paragraph of Lord Hoffman's decision. And if you call that one up on the screen at EB 738. Have a look at 41. It's set out in my note. And he says he rejects again a rerun of the Mr. Irwin QC's argument at the beginning of 41. You see that's the second to the fourth line. No inconsistency, it said, because Mr. Gray, just like Mr. Clunis, was not being punished, but subject to a hospital order, and that he was not therefore as blameworthy as all that. No goal of the criminal law would be frustrated were he to be awarded compensation. Now, the answer to that is then in what follows, in the section that begins, the sentence imposed, I'm going here from the note, the sentence imposed by the court for a criminal offence is usually for a variety of purposes. Punishment, of course, not in our case. Deterrence, or reform, sorry. Deterrence. I made my point on deterrence earlier on, that it's an absurd suggestion that it's going to put off. It's going to somehow affect, less people will be killed when they're in the position that our client was. Protection against the possibility of further offences, of course, that comes into our case. It would be impossible to make distinctions on the basis of what appeared to be its predominant purpose. In my view, it must be assumed that the sentence, in this case, the restriction order, was that the criminal court regarded as appropriate to reflect the personal responsibility of the accused for the crime he had committed. As one commentator has said, tort law has enough on its plate without having to play the criminal court's conscience. So here we have again an automatic assumption, not presumption, which is in effect both a factual and, in this case, a legal fiction, because he's drawing an element of responsibility. I accept, of course, the mens rea argument, but that it flies in the face of what the criminal court was actually saying, and therefore what you can assume is the policy of the criminal court in this case, which is that she wasn't to be punished. So the presumption, this 122, the presumption doesn't flow from the hospital order. It comes apparently from the restriction order. Now, we know that with respect is not a reflection of the law because of what Lord Phillips set out at 8 and 9, quoting Lord Mustill in a case called Queen and Drew, which is a hospital order is not a punishment. And then you can see the rest of his quote at the foot of page 32. And then 124, Lord Roger, even with a restriction, it is not to be regarded as a punishment, 749, although accepted, he went on to say, this does not mean that the judge was treating the claimant as being not to blame for what he did. So there, what is happening is Lord Roger is flagging up the fact that in the Gray case, there was significant responsibility. Compare our case where there is none. So it would appear to us, 125, that the respondents also agree with this point. At least they don't argue in their written case that a hospital order is a punishment. And there you've got the reference to the relevant part, 40 to 41. So having then referred at paragraph 44 to the rule being based on unspecified policy grounds, could we just turn that up, 739, that's on the next page. We see at paragraph 44 a specific reference that the narrow rule stops the loss of liberty claim because of the inconsistency of requiring somebody to be compensated for a sentence imposed because of his own personal responsibility or for a criminal act. And then if you just flick on quickly, you scroll down to 69, which is at 747 of the bundle. That's something that Lord Roger also agrees with, by way of punishment for a criminal act for which he was responsible. So responsibility is something that is, again, another golden thread that goes throughout the majority decision in Gray, and it is simply inherent within that little part of the impairment, that remaining responsibility that remains from the diminished responsibility plea. Now, if I take you then to the reservations, that's page 33 onwards, there's the triviality reservation at 129 to 130, which I won't go into. That's where there's effectively no connection between the crime and the punishment. So the offending behavior played no part in the decision to impose the hospital order. Now, we can't say that really in this case because plainly there was a section 41 order was imposed. It's the second situation that we're interested in at 132. More difficult is the situation where it's the criminal act of the defendant that demonstrates the need to detain the defendant, both for his own treatment and for the protection of the public. The judge makes it clear that he does not consider that the defendant should bear significant responsibility for his crime. I would reserve judgment as to whether ex turpi causa applies in either of these situations, but we didn't hear full argument. In so doing, I take the same stance as Lord Roger. Now, there was a complicated and very lengthy argument as to precisely what was the majority, whether or not there was an alternative majority making up the either the triviality reservation and or the second reservation. That's a battle we fought and lost up to the Court of Appeal. And we've effectively conceded for the purposes of, I think it's paragraph 6 and paragraph 9, I'll come to that, of our case, I'll come to that in a moment. But we are saying that when you're looking at this, you should really adopt, because at this level, it doesn't really much matter. We say that substantively, our submission is that Lord Phillips was absolutely correct in saying that the law has got to take account of that element of personal responsibility in circumstances where it has been caused by a mental disorder. And that reflects exactly what the Law Commission was saying. Just as I'm passing the Law Commission's approval of Clunis, and by reference, if they were to have looked at Gray, or having looked at Gray, is only on the basis that they are approving it because the courts were dealing with somebody who was responsible. They are not dealing with somebody who was not significantly responsible. And it's on that basis that we go on later in the note, and I've already referred to this, to distinguish Gray from our case, if that was a route that the court wanted to take. you see the quote pulled out, I think, from the top of page 35. It would be quite inconsistent to imprison or detain someone on the grounds that he was responsible for a serious offence and then to compensate him for the detention. That, I think, is a quote from Lord Roger. I made submissions on Gray then from 135, all of which I have effectively covered already, or up to 139. But could I ask you to just then concentrate on page 37 from 140 downwards, or onwards rather. Secondly, the criminal disposal was not penal, unlike Gray. The restriction order is all about public protection arising from mental illness. It is not punitive and says nothing about a person's responsibility for the offence. Now, once that is appreciated, this is paragraph 41 of the note. We've got that. If you go back to paragraph 41 of Lord Hoffman, at 738, we say that if we're right on that, and Lord Roger agrees, and if he can't hold on to the restriction order, which imports punishment on his analysis, and because it imports punishment, it therefore implicitly imports responsibility, the whole pack of cards, we say, collapses. 142, it was quite simply an error on Lord Hoffman's part to think that. That appears to be acknowledged and agreed by both Lord Phillips, you have the references there at 142, and also by Lord Roger. So if there is no penal element, if the sentence handed down by the criminal court, i.e. our case, does not contain that penal element, there can be no inconsistency between the criminal law and the ordinary rules of tort law.
Well, Lord Roger identifies an inconsistency at paragraph 79.
Say that again, I'm sorry, my lord.
Well, Lord Roger, as you say, rejects the idea that the hospital order is punitive, but nevertheless identifies an inconsistency at paragraph 79. The inconsistency being that the criminal court has decided that the claimant ought to be deprived of liberty for protection of the public, and the civil court being asked to say that the claimant should be compensated for the consequences of the criminal court's decision.
Again, to confuse, I say with respect, the role of Section 41. Section 41 is all about responsibility from somebody who may or may not in the future pose a danger to the public. It is not related in any way to her responsibility. It is not a sentence in itself. The thrust of Lord Hoffman's analysis is that it was penal. So once the concession made as it has to be by my learned friend Mr. Moon, and looking at, we were having this argument with Lord Hoffman, well, once the penal element has gone, what is left? Then with the greatest of respect, it is to scrape the barrel to then suggest that it's the element of protection that somehow brings in incoherence. When the point about residual responsibility, that just has to be put into the mix. But once the penal element goes, then there is no question of one arm of the system of law creating a significantly profound collision with the other crime to justify such an extreme measure as eliminating all loss. Now, Mr. Moon might come back and say, well, I'm not seeking to eliminate all loss. I'm just trying to look at heads of loss, and we'll pick off loss of liberty, let's say. Maybe she can have the rest. Well, that's something that Hall and Herbert, I think, touches on. That it's more extreme to deny a duty of care than it is to bring this factor in at the illegality stage. But my short answer to your point about protection, my lord, is that
it's not my point. It's simply
sorry,
it's Lord Rogers.
Your potential attraction to Lord Rogers' point. So moving back onto the note, I think 143.144 is all about the penal nature, and the fact that gradations of responsibility, i.e. monism, continue to dominate the analysis, and they dominate the analysis. We know as far as the lower courts are concerned, because even triviality doesn't come into the majority decision. Now, 147, the respondents argue at paragraph 22 of the written case that Gray is not a rule-based but implicitly a flexible Patel-compliant test, because the reasoning in that section is that Gray was approved of in Patel. Now, what we say about that is that, this is 148 through to 149, is that read or analysed properly, we respectfully submit that there was no question of Lord Toulson or anybody else in the majority approving of the ratio in Gray, to the extent that it certainly covers a case like this, or even more importantly, sorry, the point I should have made, is that the approach in Gray and the narrow and the wide rules in Gray are able to reflect the same flexible approach that is inherent within Patel. And I rely there on Lord Sumption, talking again on this very subject at 793 of the bundle. That takes us straight into Apotex, and it's paragraph 19. The whole paragraph is relevant. Could I just take you to, in fact, could I just ask you to quickly read paragraph 19? I think it's just worth the time to do that. So you have that, my lord? So you can see, particularly from the last 4 or 5 lines, there's a very clear statement that proportionality, significance of the turpitude, the merits, they just don't come in. And his view is supported, and I've set this out in the rest of the note, by a miscellany of legal experts. Bottom of 39, we've got Dyson. Then we've got Mr. Goudkamp in several different articles, and the Law Commission themselves, essentially saying You can read all of that material yourself, but essentially saying that the wide rule cannot be justified. I won't go into the wide rule in any detail at all, really, but if I could just identify it at the note from 162 onwards, you can see there, again by reference to Mr. Goudkamp's material and also Lord Sumption at 169 onwards of the note, page 46, that the wide rule serves no useful purpose. Mr. Goudkamp went as far as saying Gray is a poor decision. Although their lordships had the opinion of McLaughlin, Jay and Hall to guide them, they struck off in the wrong direction. Similar material and a long hard look in that article. Wide rule, a mere restatement of the causal rules of negligence. That's the view also of the Master of the Rolls in the Court of Appeal in Gray. Wholly unnecessary as the ordinary rules of tort law suffice. In fact, it confuses them. And then we've got another reference to Sharon Erbacher at 171. So my conclusions on the wide rule, it can't be justified on the basis of the twin policy justifications as put forward by Patel, i.e. profit, provide inconsistency so profound that it causes a fissure in the law. It's not incoherent. These are the 4 points of paragraph 47 of the note. It's not flexible, it's not Patel compliant. Accordingly, this court should depart from it. So that's really everything I think I need to say about that aspect of Gray. The turpitude section starts at paragraph 48. And again, I have covered most of this. It's fairly short anyway. There we say there is the threshold test. Even if I'm wrong on the threshold test, an element of the personal responsibility question is what I made at the very beginning of my submissions this afternoon. The personal responsibility issue then comes into Patel. XX, paragraph 178, I referred to that earlier on. And the rest of the material there, going through page 49, page 50, I don't need to deal with. I'll just check one thing, my lord. Earlier on in the note, I set out the differences between this case and Gray and Clunas, and I read that in as well. Essentially, it comes down to the same point, which is that we were always saying that the majority in Gray, or the ratio in Gray rather, should be restricted to those with personal responsibility. And that brings me on there in the 25 minutes or so that I've got left to my third issue, Patel, page 52 of the note. What I deal with up to the next three pages, so up between page 52 and 55, that's the question: should you keep hold of the Patel balance yourself as an appellate court, insofar as you decide that Patel is the applicable test? And first point we make at 186 is when we agreed the fact that there should be a preliminary issue, something that is often said to be potentially a treacherous shortcut at the best of times, is of course Patel, the decision in Patel had not at that stage been reached. The court delivered Patel in July 2016, and I think from memory the order was made in February 2016. So our arguments at first instance and the material that we put in around simply the second exception, the fact that our whole argument turned on Lord Phillips, paragraph 14 and paragraph 15. We had a psychiatrist on hand, Dr. Courtney, to give evidence to the judge on any different further aspects of personal responsibility that either the judge or Mr. Moon for the respondents, or indeed ourselves, would want to bring out. As it happened, they didn't wish to cross-examine him, so no evidence was called. The evidence that we say is missing, we then go on at paragraph 193 onwards to have a look at what you might want to see. And I think we accept that in terms of the prohibition, because we say the deterrence argument is ludicrous, at the foot of page 53, we don't really see much need for evidence in relation to that, even though there's no trial. But at the second stage, we would want to obtain evidence to meet the various policy arguments that the respondent runs. They talk about resources, floodgates. You've got the references there. I'm at the top here of page 54. And to back up the appellant's assertion at paragraph 81 of our case that these claims are relatively uncommon. So it's not an undue. So it's not, forgive me, so it's not an undue burden on the NHS to allow them. And whilst I'm on that point about resources and burden, just to make this point now, the burden in terms of resources, and looking at, if one looked at the justification that Lord Hoffman raised, a sort of general policy point to justify his wide rule, the reality of what's happened here, the agency at fault, admitted fault, the mental health professionals. As a result of that, the burden to the taxpayer is massive. It's treating and containing and caring for somebody for decades. As a result, now compared to compensation, we even got into quantum and what this case might be worth. But again, that's an interesting, just an interesting point to take on board, albeit the proportionality one, which I may or may not be able to get to. But going back to evidence, to support this is little two, to support the submission that the policy of paying compensation for those who have been injured drives up standards. Now, we've just taken a link there off the web in terms of a policy document, 5-year forward plan. We've not put that before you. It's publicly available, so you can see it yourself. But there it's accepted that, of course, learning lessons, it's a platitudinous point in many ways, but the learning lessons from this type of tragedy, i.e. not only inquiries and post-killing investigations, but the effect of tort law having a clarifying and instructive effect on public bodies. I mean, it's an argument that my lords, my ladies will be very familiar with, that Lord Bingham particularly has said in the past that the major policy of the law is that rights should be wronged, and of course having a duty of care drives up standards. So all of that is implicit in what we're saying, but query in a medical, in a mental health context, whether you've got enough to be able to look at the Patel issue properly. So then we get to the third stage, and the court will be required to balance off the respective wrongfulness, on the one hand, the level of responsibility retained by the appellant who killed while psychotic, and the level of wrongness, let me put it, if there is such a word, in relation to the NHS. And again, this is where we get to the point that the respondents were so keen to simply argue even this fourth, or issue 4, my third question, within the sort of almost camouflage of the SFI, with a sort of en passant reference to an untoward incident. It might be important to really understand, in terms of the proportionality question, exactly what they did or didn't do. Exactly, I know there is no such thing in civil law as gross negligence, but there is again a continuum. Exactly how bad was this case? Exactly how bad was it on a personal basis? And I have enormous sympathy, as everybody does in this kind of case, for the individuals who are targeted by a negligence claim. I completely understand that. And I'm not making any point as to how bad it was, because we can't get into the facts, they're not in front of you. But as well as that, there's sort of vicarious, and we call it the vicarious element. There's also the systemic or structural problems that existed as a result of the failure of the safety net. That is contained in 220 pages of dense analysis by, I think, independent analysts or experts who were employed specifically by the respondent in this case to look at what happened. We wanted to put it before you. The NHS, or this defendant rather, were not prepared to have it in the bundle. So if you want it, it's available, and that material is there. Now, of course, I have to concede that if you get all of this material, you feel it's either available or that directions are made to enable us to give it to you, then perhaps on that basis, this isn't the concession, but I'm just sort of making this point and showing how flexible we are, that it may well be that the appellate court could carry out the function of a first instance court. But that wouldn't include, if it was necessary to hear oral evidence in terms, for instance, of a personal gradation of personal responsibility issue, then we would have to hear them from the psychiatrists, and that plainly can't be achieved. So that's what I say about why it should be remitted. And my primary submission on that is that it should go back. You should not get involved in that aspect. If, however, you do, you have the benefit, if it is indeed a benefit or a burden, of page 55 through to 72 of this note, which then seeks to set out in a structured way precisely what we say in relation to all three stages. Well, I've got 15 minutes or so left, so I'll just try and cover this quickly. The first stage, well, would allowing the civil claim somehow undermine the purpose of the prohibition? The prohibition being not to kill. A point that is made by at paragraph 196 of my note, made by Dr. Dyson, is that the question that you should be looking at is whether the earlier proposition is actually being undermined, rather than a speculative possibility that it could be shown not to be true. So the question for the court, 197, is therefore whether the purpose of this prohibition, i.e. to prevent unlawful killings, will actually be enhanced by the denial of the claim. Now, I've made my point on deterrence. Nobody who is in the grip of a psychotic attack with no capacity is going to stop and say, oh, I won't be compensated. So we say there's absolutely nothing in this point at all. Paragraph 200, invoking the illegality defense to deny a civil claim as deterrence is not a convincing argument in general. We again rely on one of Mr. Goudkamp's articles. And he says there, it does not, it's another deterrence point, it does not deter offending, since the claimant who is contemplating whether to commit a crime are unlikely to think about the consequences. So it's the same point. The Law Commission as well are of the same view. Paragraph 201, same point. And then 202, going one step further, Dr. Dyson says that because the appellant has no significant personal responsibility, there is no significant infringement of the prohibition. So the actuality is that in effect, in a case like Henderson, there would be no application of a criminal prohibition relevant to the policy of tort law, because the criminal law had made a finding that there was no personal responsibility. Read in there everything I've said about no penal aspect. And then illegality zero sum torts. This is the work by Sarah Green, who I believe is now, I think, a law commissioner. In fact, the most effective way of deterring people like Gray from killing would be to manage mental illness effectively. Thus, on these facts, the question of how best to honour the underlying purpose of the rule against unlawful killing is not independent of the second consideration of whether there are aspects of public policy which would militate in favour of rejecting the defence. And so it goes on. And then if you look at the last 4 lines, public policy question of altering the behavioural incentives, potential tortfeasors, is coterminous to the question of respecting the underlying purpose of the prohibition of homicide, not a countervailing consideration. Then we've got Mr. Goudkamp again, 2 more quotes there. I think I've already made my point upon goal and the other form of pronouncement consistency. So there is no, I'm moving on now to 206. This is the point that the respondent makes about declaratory purposes. We don't really follow this. We say it's really an academic or theoretic concern when the what really actually matters is the prohibition being somehow undermined, and we say not. There's a point made on Ashley at 209, when again, that is again very general, just a generic statement that tort and crime have to march together. That doesn't, I say, develop the argument at all any further. Second stage, I'm now on to policy. When countervailing policies are considered, we say look at the big picture. You don't look at the in relative terms, micro aspects of defensiveness, multidisciplinary decision-making, resources, all of that, all of the Exon Bedfordshire stuff that has been worked through in the last 20 or 30 years, coming up to Michael, where it's sidelined with the possible exception of resources. All of those points go to the existence of a duty. They should not go into the Patel aspect. If you feel that they do go into the Patel aspect, we need to be able to answer them properly, which we can't, and that's my point on remittal. We identified, I think, 4 policy points, and you see them there at 212. I'm only going to have time to deal in any detail at all with the first one. And in many ways, it's self-explanatory. That the countervailing policies against the policy in the legislation that one must not kill. In fact, I think there is no law against killing. There is a law against culpable killing. And of course we accept, however one puts that, of course we accept the power of that. But if the killing would never have taken place, but for the foreseeable consequences of the negligence, then what I have at 2121 comes in very, very, very heavily into the balance. The policy of encouraging NHS bodies to competently care for the mentally ill. And for that, you see we developed that at 213 onwards, and the point about resources, about policy I've made 213, 214 onwards. So 216, 217, 218, the point I'm making there, and from the CNGN and pool litigation, this will again be familiar territory, that putting all of that back in at this stage is revisiting the duty or no duty point. So it's a sort of second bite at the cherry. Then we get to various points made by my learned friend on about competent care for the mentally ill. And I can read in 220 through to 225. Yeah, there's another evidential point made at 225. But it's the same point I've already made. Take judicial note that negligence claims can improve standards, and then again a reference to the same link. 226C, the option to use professional regulation disciplinary measures relying on the refusal to impose a duty of care on the police in Michael. That's a point that's made against us. And again, this is where, forgive me, it's exactly the same point. It's again a meta point that should come into duty, not into the second stage of Patel. The rest of page 227, 228 is the same point on different types of policy. And then we get to policy of fair compensation to victims of torts when they are not responsibly significant for their conduct. But we've got nothing to add orally. You've got the references there at the top at 228 square bracket 2, and very much the same. The next policy of ensuring that public bodies pay compensation for those they injure. You've got the references there to where you find it in our case. In many ways, the very thing that the duty was there to achieve has happened in this case, i.e. the avoidance of an untoward incident, in this case, a foreseeable act of serious violence. And then at 230, you see pulled out from the report, the passage in bold that makes good what I've already said. Serious untoward incident of some kind was foreseeable based upon her previous behaviour when experiencing a psychotic episode. I won't turn it up, but at Annex 1, I think it's Annex 1 at 111 from memory, you will see some of the material, which included fantasies about stabbing her boyfriend, another incident where she, I think, tried to stab a patient in the top of her head with a cutlery knife whilst on the ward. And whilst she was well, she was low risk. But when she was unwell, she was really very high risk. And that's why, that's why we, that's why it's common ground that there should have been an instant recall in the event of her relapsing. That moves me on, I think, to proportionality. And the proportionality section starts on just a couple of points on forfeiture before I get to proportionality in the 5 or 10 minutes or so that I've got. The forfeiture argument in this note comes in at 235 to 238. And what we say about this, the Court of Appeal felt rather strongly, we say rather unfairly, that this was an egregious part of the claim. It was an egregious part of the claim because of the statutory rule, the forfeiture rule, that if somebody is going to benefit from, going to be a beneficiary from the estate of somebody they've killed, then they lose it subject to a discretion that it should be reinstated. And I think it was reinstated by a consent order, so there was no order of the court. And we say we've got two main points in relation to that. The first is what the respondent says at 97 and 98 of their case, which is that it increases the value of her claim, and that can't be right. Well, that's exactly what the House of Lords dealt with in the well-known case of White and Jones, the solicitor beneficiary duty to third party beneficiary case. And Lord Gough gave very short shrift to exactly the same point. And you see it in bold at the bottom of paragraph 238. I cannot, however, see what impact this has on the disappointed beneficiary's remedy. It simply reflects the fact that those who received the testator's estate, either under an unrevoked will or an intestacy, were lucky enough to receive a windfall, and in consequence the estate is, so far as the testator and the disappointed beneficiary are concerned, irretrievably lost. And then Lord Nolan also agreed, and you see the reference to that at the top of the page. So we say here that in relation to the points generally taken by the respondent, certainly the point, I think, about the increase in the value of the estate, it's a new point. It wasn't taken at first instance or in the Court of Appeal. The fact that it should emerge at this stage highlights the difficulty of this court having to deal with it through the lens of the Patel test. That's not an easy point, but what we say is really as follows. Section 2.6, particularly of the Forfeiture Act, cannot possibly bar the claim. This is a claim for damages. It's not a benefit within the meaning of Section 1 of the Forfeiture Act. You won't find this in the note, incidentally. It's a claim for compensation to put Ecila Henderson in the position she would have been had there been no tort. Of course, she's only in the position of having lost her inheritance rights as a result of somebody else's negligence. So secondly, the damages do not arise on consequence of the killing, as Section 1 requires. The damages arise as a result of the negligence which arose before the killing. So in addition, we say that if the respondent had satisfied the duty of care, which they admit they owed, then there would never have been any question of an issue of forfeiture, because the crime would quite simply never have occurred. And just finally on that, how does the forfeiture rule work? How does it really affect all the arguments? And this is a response again to the egregiousness of the nature of the claim. So says the Master of the Rolls in this case. Forgive me, this may or may not be repetitious. Different rules to a common law claim. It was a consent order, so not a considered decision of a judge. Query how the issues were handled, how was she advised. Fundamentally, is a different new point. Fundamentally, it's arising here between Ecila Henderson and the court. Sorry, in terms of the Forfeiture Act, it's not between her and the court. The issue is between her and the wrongdoing tortfeasor. And then in terms just finally on proportionality, a lot of proportionality I've dealt with, I think, as I've gone through. It's Lord Toulson at 108. The division of responsibility between the criminal and the civil courts means that wrongdoing is the responsibility of the criminal courts, with a broad principle, not in doubt that the public interest requires that the civil courts do not undermine anything. But here, there cannot possibly be any undermining if really the main plank of our case is right, which is that there is no significant personal responsibility. Respect for integrity or justice of the justice system is not enhanced, so says Lord Toulson, if it appears to produce results which are arbitrary, unjust, or disproportionate. So I say the disproportionality here is between the seriousness of the negligence, the consequences of the negligence, and on the other side of the balance, the fact that there is some residual responsibility as a result of the way that the criminal law is currently configured, enabling us to have to face up to the fact that there is some residual mens rea. In terms of Professor Burrows' list, which you see at paragraph 93, I don't have any time to turn it up, but it's parts of it are taken by Lord Toulson at I think either 107 or 108. Seriousness of the illegality, whether the party seeking to enforce knew or intended the conduct, centrality, the seriousness of the sanction. We're just whipping through that really quickly. Seriousness, of course, we accept utmost severity of the event. Intention, well, she didn't have any, she was floridly psychotic. Centrality, the appellant submits that she has a completed cause of action against the respondent before the killing. It's not central to the claim. It's a consequence of the negligence. Seriousness of denial of the claim, well, perhaps I probably don't need to say any more on that. Could not be more significant. A matricide, a dead mother, a destroyed life as a result of breaches of duty, for which, if Mr. Moon's case is right, she will receive nothing. And then at 244, I get to some material which I'm perfectly happy for you to read into. Maybe I'll look at 244 then, unless there's anything else, my lord and my ladies, I'll finish. At a macro level, we say the denial of the claim does not further the prohibition against killing one little bit. So there's no chilling effect here. A number of public policies will be rendered less effective if the claim is denied. And then, given her lack of responsibility for the killing and the negligence of the respondent, proportionality is in our favour, and it's not proportionate to deny the claim. And then, if I add a little d into 244, there's a marked disparity when you compare her lack of responsibility and her lack of culpability with the seriousness of the breach. And then what remains are more detailed points on precisely how that affects the individual heads of loss. And I'm content for your lordships to just read that, which is developed reasonably well, I think, in our written case. Could you just give me one moment? Yes. Yeah. The alternative test, the fourth issue at page 74 of 255 onwards, really, I mean, it's very short. I've covered it already. If the Patel test is not to be applicable, well, what do you do? We've already covered this to some extent in the interchange we've had about the impact of contributory negligence. Supported by the academics, again at 255, you've there got a quote again from Sarah Green. We've got Professor Green, forgive me, at the foot of 255. If I could just read in a tort inquiry, etc. We've then got, I've referred to his lordship many times already, the full quote of Sir Anthony Clark is in there. It's far from clear to us why the ends of justice are not sufficiently served by the principles of causation, contributory negligence, without the need for a further principle of public policy in such a case. It was no doubt this reason that Lord Justice Old said obiter in KR against Bryn Allen. Notwithstanding anything said by this court in Clunis's case, any argument might survive that damages are recoverable in respect of tortious acts that have resulted in a law-abiding citizen becoming a criminal. So we say that there are ample reasons to allow this appeal. The most important one being her distinct lack of personal responsibility, which runs through everything. And I think I've had my extra 5 minutes. Now it's 2:05. So unless there's anything else, my lord, those are our submissions.
Thank you very much, Mr. Burgo. I think Lady Arden has a question.
I'm sorry.
In forfeiture, the policy is spelt out in section 1 of the 1982 Act as being to preclude a person who's been guilty of killing a person from inheriting anything under their will, if I put in my own words. Why doesn't that statute prevent the courts from granting any further compensation?
Because if that point is a good one, it should have gone to duty. That's one point. The second point is if there is a concern about the applicability of the Act, then the Patel test is more than sufficiently flexible to be able to bring that into the balance. And it may be, I'm not making any concessions at all, but it may be that when the Patel test was then applied, that there might be some form of discount to say, well, you can recover heads 1, 2, and 3, but insofar as head 4 involves an attempt to get back that part which you lost as a result of the consent order, that will be, it would be disproportionate to allow that in.
Perhaps I wasn't clear. I was meaning that Parliament has decided how much a person should get in that situation. It's to be fixed by application under the Act. So why doesn't that preclude the court from giving any further compensation? I appreciate from a tort committed by a third party, but on the basis that the courts don't undermine Parliament's legislative purpose.
Because the legislative purpose has already been undermined to an extent by accepting that she can only have half. That was a consent order. Precisely the basis of that, it wouldn't be any form of abusive collateral attack for the court to look at that again and to decide how to balance everything up under Patel. And perhaps more importantly, we are not here dealing purely with a statutory process or exercise. We're dealing with a common law claim, and at the moment something that could have come in to the earlier liability stages, but of course has been inappropriately, we say, placed at the back end, not the front end.
Thank you.
Probably isn't an answer, but it's the best I can do at the moment.
Lady Black.
Can I just ask you a factual matter? I think that you are differentiating between the degree of personal responsibility Mr. Gray had and the degree of personal responsibility in this case. I was wondering how you draw that comparison.
Well, we rely there on the, and we can send you a note on precisely where you'll find that in the earlier judgments. But that was a trail that was blazed by Mr. Justice Jay, and from what we read in, what the judges read in to the way that the cases were reported, also by looking at the first instance decision from memory from Mr. Justice Flo. And I don't think we've got, do we have Mr. Justice Flo in the bundle? I don't think we can get Mr. Justice Flo for you, but I think it was common ground with the respondents team that it was agreed that that both Gray and Clunis were cases of significant responsibility, if only because, of course, that point is really made by Lord Hoffman and Lord Roger, and also by the Court of Appeal in Henderson, looking at the House of Lords decision, to say that they felt that there was a sufficient degree of personal responsibility. So that those suggestions, so forgive me.
It was the same penalty that was imposed as in this case.
Yeah. Yes, but of course one can't derive precisely where you are on the continuum from the outcome.
Thank you very much, Mr. Bowen. We'll turn now to Mr. Moon.
Sorry, forgive me, there's just one point. I've just been prompted. Section 45A was not available at the time.
It's discussed, isn't it, in Lord Phillips' judgment as having since the events with which Gray was concerned.
I think Lord Phillips's judgment refers, to the background to Section 45A by reference to Drew and Birch, but it's on ground that when Mrs. Justice Rafferty sentenced him, it wasn't an available option.
Okay.
Thank you. So I'm sorry to interrupt.
No, not at all. Yes, Mr. Moon.
Lords, my ladies, our submissions are made in three parts. First, a short summary of our case, the respondent's case. Then we address the 6 issues, focusing particularly on the second issue, the question of whether this court should depart from Gray, which we say is central. And thirdly, we make some submissions on the appellant's core propositions and some of the things that Mr. Bowen has submitted today. In particular, I'm going to come back to the suggestion he made just a moment ago that there was an agreement that both Mr. Gray and Mr. Clunis had significant responsibility. I'm afraid that is not my recollection of what was agreed, and we will see that in the course of the judgments in those cases. So if I can start by a summary. Although the appellant has, we say, sought to travel outside the agreed statement of facts, they were agreed for a purpose, these facts are inescapable. The appellant killed her mother by stabbing, was convicted of manslaughter and was detained under sections 37 and 41 of the Mental Health Act. And the respondent says it would be contrary to the public interest because it would be harmful to the integrity of the legal system and bring it into disrepute to allow claims for loss which result from the conduct which led to her conviction and from the disposition made by the criminal court following that conviction. And we submit that this court should follow the decision of the House of Lords in Gray, a relatively recent decision, to the effect that her claims should not succeed, thereby maintaining consistency between the civil and the criminal courts. There plainly is a significant difference. That's the end of my summary, but I wanted to add this. There plainly is a very significant difference between the understanding reflected in Mr. Bowen's submissions about what consistency means and what we say consistency means. And I will come on to that in due course. So the first issue in summary is whether the heads of loss claimed are irrecoverable in accordance with Clunis and Gray. Now until today, we had understood that that was conceded. In other words, it was conceded that the heads of loss claimed cannot be recovered under the ratio in Gray. And the reference there is page 69. I'm going to make a number of page references. Unless I take you to them, please, if you don't mind, given the time, I'm not going to take you to all the references. The ratio in Gray, we say, was that in the context of a criminal conviction for unlawful killing, there is a wider and a narrower form of public policy which precludes a killer, a claim by a killer, from recovering damages for negligence against a person whose negligence was responsible for bringing about the claimant's unlawful conduct in carrying out the killing. That's the ratio. The reference for that is page 188. Now, before both Mr. Justice Jay and in the Court of Appeal, the appellant contended that this case was not covered by the ratio in Gray, essentially because of Lord Phillips's reservation in paragraph 15 relating to the person the sentencing judge said did not bear significant responsibility for the crime. And what Mr. Bowen said at first instance and in the Court of Appeal was that that reservation, the reservation relating to the person who didn't bear significant responsibility, was shared both by Lord Brown and by Lord Roger in Gray, and therefore the ratio in Gray didn't apply to this case. Now, both Mr. Justice Gray and the Court of Appeal rejected that contention, and they did so essentially because Lord Roger did not share Lord Phillips's reservation on that case. Reference page 218, and the Court of Appeal's judgment on that is at page 190. Now, we had understood from the written case that the appellant no longer advanced that argument and now accepted that the ratio in Gray covered her case. And I was simply going to say that that's plainly right, because Lord Roger didn't suggest that the decision, his decision or the decision of the House of Lords in Gray, didn't apply to those who lacked significant responsibility. And the reason for that is because it in fact was not clear where Mr. Gray was on the continuum of responsibility of those convicted of manslaughter. The reference for that is page 71, and it certainly was not agreed by me or anybody acting, as far as I'm aware, on behalf of the now respondent, that Mr. Gray had significant responsibility. On the contrary, what the judgments, both the judgment of Mr. Justice Flo, which we don't have in the bundle, and the judgment in the Court of Appeal and the judgment in the House of Lords make clear, is that actually it isn't very clear what responsibility Mr. Gray had. But that, in the submission we made below and here, is not relevant to the reasoning. It isn't relevant to the reasoning of the majority in Gray, And in great respect to you, it isn't relevant to you either, because what is much more relevant is the question of consistency. So we submit that if grey is not to be departed from, given that it is indistinguishable, I had understood until Mr. Bowen made his submissions that this appeal had to fail if grey is not to be departed from. It now appears that Mr. Bowen is saying that grey is distinguishable, and if there's time, I will try to deal with that. Maybe I have to deal with that tomorrow, but my present position is that grey is indistinguishable, that in fact was not disputed until today before the Supreme Court. And if that is right, the only way in which this court could come to a decision different from that in grey is if grey is departed from. And we submit that, and this is issue 2, we submit that this is the most important issue on this appeal, namely whether the Supreme Court should depart from grey pursuant to the 1966 practice statement. And here there are 4 points. I am not going to make them in the same order as they appear in the written case, because the respondent's written case is quite responsive, and in that sense is quite difficult to read sometimes. I'm going to set out the points in perhaps a more logical order. The first reason why we submit it wouldn't be appropriate to depart from grey is that the threshold for departure from a recent decision of the House of Lords is high. The Supreme Court will normally treat decisions of the House of Lords as binding. We, of course, accept that departure is appropriate if the earlier decision is impeding the proper development of the law or has led to results which are unjust or contrary to public policy, or where the earlier case is causing uncertainty, so it's disapproved of by other lower courts, but they distinguish it on inadequate grounds. And I am respectfully summarising there Lord Reed's description in the case of Hudson, which is not in your bundles, I'm afraid, but is referred to in the case. I'm summarising Lord Reed's description of the circumstances in which the then House of Lords, now Supreme Court, should depart from an earlier House of Lords decision. I, of course, accept that where there are cases involving decisions of the European Court on Human Rights, different considerations may apply. And there are some very recent examples, a very recent example in a case I think called AB, an immigration case, where the Supreme Court did depart from an earlier decision of the Supreme Court, but that was because there had been essentially a change in the decisions made by the European Court on Human Rights, and we're not in that territory. So we say essentially that the threshold, the high threshold for departure from a recent decision of the House of Lords is not reached in this case, and that's our first point. The second reason for not departing from grey is that grey is consistent with Patel. Grey was considered by 6 members of the Supreme Court in Patel without any disapproval or any criticism. That is by Lord Toulson and the other 4 members of the majority, including my Lord Hodge, as well as by Lord Neuberger. And there are 3 parts in the judgment of Patel which we would ask the court now to look at in the bundle of documents. And I wonder if the court could first go to page 846 in the bundle. 846 should be paragraph 28 in the judgment of Lord Toulson. One of the disadvantages of remote hearing is it's really quite difficult to know how long to give the tribunal to get to the relevant document. You can see that when you're face to face. It's really very difficult to see when one is making submissions remotely. If I go too fast, perhaps somebody could put up the hand, but I will carry on. I'm at 846, and in this section, this whole page, or nearly all of this page in Patel and Mirza, deals with Gray, and it sets out, Lord Toulson sets out the facts of Gray, and then the rules that I have described, and then over the page, just a short paragraph at the top of page 847, Lord Toulson said this: the Law Commission drew from the various judgments, that's of course judgments in the judgments in Gray, a readiness on the part of the judges to examine the policy reasons which justified the application of the illegality defence, and to explain why those policies applied to the facts of the case. If one then, that's the judgment of the majority. If one then turns on to page 870, which is should be the judgment of Lord Kerr, and I was hoping to read from paragraph 129, where Lord Kerr said this: moreover, if the ex turpi causa axiom is itself no more than an expression of policy, the taking into account of countervailing policy considerations in order to decide whether to give effect to it in a particular instance is the only logical way to proceed. That is, it is in truth a policy-based rule, has been clearly recognised. And he then refers to Gray and to Lord Hoffman's speech in Gray, where Lord Hoffman said that the maxim expressed not so much a principle as a policy and didn't have a single basis of justification, but was rather based on a group of reasons which vary in different situations. And lastly, in Lord Neuberger's judgment at page 876, at paragraph 155, actually the relevant passage begins right at the bottom of 876, but goes over the page to 877 in paragraph 155. Lord Neuberger referred first of all to the very important case of Hall and Hebert, and to the judgment of the Chief Justice, Mrs. Justice McLachlan in the Canadian Supreme Court. And he quoted from that judgment and then said this in its at letter C on page 877 of the judgment. This approach, having referred to Chief Justice McLachlan's approach, this approach, which is more fully analysed by Lord Mance, finds an echo in Lord Roger of Earlsfrie's observations in Gray that the civil court should cleave to the same policy as the criminal court. Now, my lords, those passages show, we submit, no disapproval or criticism of Gray. On the contrary, something approaching approval of the approach in Gray. And that latter passage, in which Lord Neuberger points out that Lord Roger's speech in Gray is closely tied to the seminal judgment of McLachlan J. in Hall and Herbert, is important for reasons I hope to come back to. And our submission that Gray is consistent with Patel is also supported by what was said by Mr. Justice J, and the reference there is page 221, and by the Court of Appeal in this case. And I wonder if the court could go to page 193 to see what the Court of Appeal said about the interaction of Patel and Gray, because 193, paragraph 89, I heard something, I wasn't sure if anybody wanted me to slow down. No. Paragraph 89
Sorry, can I just ask you to give the paragraph numbers straight away, because I'm using paper copies of some of these documents rather than the bundle. Thank you very much.
So this is paragraph 89 in the judgment of the Court of Appeal. That may mean, my lady, that the references I've given so far won't mean very much to you. So paragraph 89 in the second line, and we submit respectfully that the Court of Appeal was absolutely right about this. It is impossible to discern in the majority judgments in Patel any suggestion that Clunis or Gray were wrongly decided, or to discern that they cannot stand with the reasoning in Patel. As we conclude, Clunis was approved in Gray. Gray was referred to in the judgments of Lord Toulson, Lord Carr and Lord Neuberger, but in each case with approval of the way the matter had been approached by Lord Hoffman in Gray in identifying the considerations underlying and justifying the rule of public policy. There was no suggestion of any kind that either the approach of Lords Hoffman, Roger and Scott or the decision in Gray was incorrect. And lastly, on this second reason for not departing from Gray, namely that it's consistent with Patel, I wonder if I could respectfully show the court the judgment of the Court of Appeal in a case called Day and Womble Bond Dickinson, which in our bundles is at page 1, begins at page 1264, but it's probably most efficient to go to the passage which I'm going to refer to, which is at paragraph 34, page 1275. And this is in the judgment handed down on the 4th of March of this year, 1275, my lord, paragraph 34, or two sentences. There can be no doubt that the rule in Gray was not undermined by the decision in Patel. Indeed, in the passages to which I've referred, Lord Toulson appears expressly to approve it. So that's the second reason for not departing from Gray. The third reason is because Gray identifies and relies upon the same policy reason for the illegality doctrine as does Patel. And the reason that Gray and Patel are consistent with each other is because both cases are based on the critical need for coherence between the civil and the criminal courts. Lord Toulson reflected that at paragraph 99 in Patel, which Mr. Bowen read this morning. It's page 863 of the bundle, and it simply says this: the law should be coherent, not self-defeating, condoning illegality by giving with the left hand what it takes with the right hand. And that need for coherence, we submit, is one of the main policy considerations behind both the wide and the narrow rules set out in Gray. The coherence justification for Lord Hoffman's wide rule in Gray was in fact pointed out by Lord Sumption in Patel. And I wonder if the court could go to paragraph 232 and that in Patel, and that's at page 898 of the bundle. In the passage of Lord Sumption starts paragraph 232 by referring to, again, McLachlan Jay's judgment. The English courts have taken a broader view than McLachlan Jay did of what constitutes profit from an illegal act. And can I just interpose that it's no part of the respondent's case that this appellant profited in any way. That's not the basis for the illegality defense in this case. Her rationalization of the illegality principle as being based on the consistency and internal coherence of the law has been consistently adopted in England in tort and contract cases alike by this court and by the Appellate Committee of the House of Lords. And Lord Sumption then referred to a series of cases and then ends that list of cases with a reference to Gray at letter C, where he said that Lord Hoffman put forward the principle of consistency as the rationale of what he called the narrower rule precluding the recovery of damages representing loss directly arising from the sentence of a criminal court. He was inclined to think that the wider rule that a person cannot recover for damage which is the consequence of his own criminal act was based on a different principle concerned with public notions of fair distribution of resources. And CF Lord Roger of Earlsfree at paragraph 84, and that CF is in our submission really quite important. I'll come back to that if I may, but what Lord Sumption says is certainly the inconsistency of awarding damages representing loss arising from a criminal sentence is more obvious and direct than it is when the claimant is claiming other damages flowing from his commission of a crime. But it seems to me, as it did to McLachlan J and those who have adopted her approach more generally, that the internal coherence of the law is also the reason why it will not give effect to a civil court, in a civil court, to a cause of action based on acts which it would punish in a criminal court. And what we submit is that what Lord Sumption is there saying is both the narrow and the wider justification, what wider rules are justified by the need to ensure coherence. And that is why, and I'll develop this a little in a moment, that is why Lord Sumption did not repeat in Patel the criticism of the wider rule that he had advanced in Apotex, which my learned friend relies upon. Nowhere in his speech in Patel does Lord Sumption say that he doesn't like the wide rule because it's disproportionate. Actually, his thinking, if that's a proper description for the reasoning of a Supreme Court judge, his thinking has moved on from having been about having been somewhat critical of the wide rule into what we would submit is an appreciation that the wide rule is also justified by the need for coherence. And the reason for that is because the civil court should the civil court should not permit a claim based on the acts which have been punished in the criminal court. Could I then go back to Lord Roger's speech in Gray to look at the paragraphs that Lord Sumption, or the particularly paragraph 84, but also one or two other paragraphs in Lord Roger's speech. If it's paragraphs 77, 84 and 85 for Lady Black, if my lady has that only in hard copy, but in the bundle it's 749. And I was going to start paragraph 77. Because here Lord Roger refers to the Zastowney case, and he says, in that case, Rothstein J treated the need to preserve the integrity of the justice system by preventing inconsistency in the law as a matter of judicial policy that underlay the extirpi causa doctrine. Then he talks about the circumstances of that case, and then says at letter B, towards the end of the line, in Zastowney and the preceding cases, the need was to ensure that the civil and criminal courts were consistent in their handling of the plaintiff's criminal conduct, and I would underline that word, and its consequences. That is simply one manifestation of a desirable attribute of any developed legal system, and he goes on to talk about Roman law remedies. And then over the page, please, to paragraph 84, having dealt with the narrow rule, this is what, in my submission, Lord Roger is saying about the wider rule. The claimant has a number of other claims for damages which were not explored in detail at the hearing. In particular, he has what is described as a claim for an indemnity against any future liability in damages to the dependents. That's the dependents of the person who was killed. A claim for economic loss. He has a claim for his feelings of guilt and remorse. as my noble and learned friend Lord Hoffman says, these claims are not a consequence of the sentence of the criminal court and so cannot be disposed of on the ground of inconsistency. Nevertheless, I agree with him, they should be rejected. And he then refers to Rothstein J's judgment in British Columbia and Zastouni and says that a person is not entitled to be indemnified for the consequences of his criminal acts for which he has been found criminally responsible. He cannot attribute them to others or seek rebate of these consequences. Yet that is precisely what the claimant is trying to do. So we submit that Lord Roger and Lord Hoffman justified the narrow rule, that is the rule which prevents recovery of damages relating to what is happening during the course of the sentence or during the course of the disposition imposed by the criminal court. But he also justifies, as does Lord Sumption in Patel, the wider rule on the need for coherence, in the sense that the claimant isn't entitled to be indemnified for the consequences of the criminal acts. And that wider rule is, we submit, justified by the need for coherence. And that point was also picked up by the Law Commission in their consultation paper. And it's the 2001 consultation paper of the Law Commission, paragraph 4, full stop 70. And the relevant passage is 3077. At this point in the Law Commission's paper, the Law Commission is examining the various rationale, the various bases for the illegality doctrine, and is considering the rationale of consistency. And at paragraph 470, in the first sentence, the Law Commission deals with the question of profiting or benefiting from wrongdoing. And in the third line says it can be argued that it would be inconsistent for the law to proscribe certain forms of conduct on the one hand, but to allow someone who has committed such wrongdoing to benefit from them. This appears to us to be a parallel case to that of allowing a claimant to recover compensation for the consequences to himself or herself of his or her criminal act, just as a person is not allowed to claim to recover the damage arising out of the criminal act that resulted in conviction and sentence. So he or she is not allowed to take any benefit from the wrongdoing. So that's reflecting, we say, the same point about the need for coherence, underscoring the wider rule as well as the narrow rule. The fourth reason for not departing from Gray, the first three I have dealt with, I hope. The fourth is that the criticisms of Gray are unjustified, or at least not sufficiently damning to justify departure from Gray. And we have tried to synthesize the criticisms which my learned friend and the appellant have made. And there are 8 main criticisms. I'm going to seek to identify them and then seek to rebut each of those criticisms of Gray. The first is that Gray is a rule-based approach. And there was, of course, criticism in Patel of a rule-based approach, like the approach in Tinsley and Milligan. We submit on that, and we can put this very shortly, that both rules in Gray were not at all rule-based. They were described as being policy-based approaches. They were based in particular on the policy of the need for coherence and consistency. So we say that's not a good criticism. The second criticism is that the narrow rule in Gray is inflexible and applies no matter what the circumstances. But in fact, it is clear from the speeches in Gray that the rule would not apply in the case of a minor or trivial offence, like a minor case of criminal damage. That was an example given by Lord Rogers, and Lord Roger at paragraph 83, which my learned friend read to you, I think, refers to that example, and also by Lord Brown. So it's not the case that the narrow rule will always apply no matter what the circumstances. But when it comes to weighing the balance, we do submit that the policy requirement of consistency and coherence trumps the need for fairness between the parties, by which I mean it is a factor that if one is going to apply the Patel approach, which we say is not the right approach, but if one is going to apply it, that factor weighs very heavily in the balance. And that language is taken from the Chief Justice, Mrs. Justice McLachlan, in Hall and Hebert. And I'm afraid I don't have a paragraph reference, but I'll try to find the internal page numbering, because I don't think at that time paragraph numbering was being used quite as widely as it is now. But it's at page 2265 in our bundles, and it's page 181 if my lady has that in hard copy. I'm afraid I can't hear you.
Can I just help you by saying that it's only the very central authorities that I've got printed out. The rest I'm managing perfectly well using the e-bundle. Thank you very much.
I'll try to make sure I give the paragraph references in the essential, the core.
Thanks.
So this is at page 2265. And at this part, this is not a part of the judgment of the Chief Justice, which is often referred to. And that's why because I anticipate that many members of the House have looked at this decision perhaps many times and this judgment many times, I just want to show the court this section. Now here, the Chief Justice is dealing with the idea that one brings the illegality issue into play at the duty of care stage rather than at the damages stage, because one of her co-judges, Mr. Justice Corey, thought the right way to approach it was to introduce illegality in deciding whether or not there was a duty of care at all. She is dealing with that in this passage. And she says in the first column, third paragraph on page 2265, I begin by noting that the duty of approach does not fully capture what we mean when we invoke the principle of extirpi causa. If what I have said above is correct, the extirpi causa principle operates most naturally as a defense because its purpose is to frustrate what would be, had extirpi no role, a complete cause of action. Liability for tort arises out of the relationship between the alleged tortfeasor and the injured claimant. The power of the court to deny recovery where it would undermine the coherence of the legal system, on the other hand, represents concerns independent of this relationship. It's important, if only for the purposes of conceptual clarity, that extirpi causa operate on those rare occasions where its operation is justified as a defense to frustrate tort claims which would otherwise be fully made out, because this best expresses what is in fact decided. The courts make it clear the defendant has acted wrongly in negligently causing harm. They also make it clear that responsibility for this wrong is suspended only because concern for the integrity of the legal system trumps the concern that the defendant be responsible. Well, we submit that that is a very important passage, because it is, of course, possible that Lord Toulson wanted to go well beyond, or at least take a different route from, the Chief Justice. But it's also clear that Lord Toulson based his and the majority's decision very much on McLachlan Jay's judgment. And this importance of the concern for integrity of the legal system is, we submit, the basis for Gray. and because of that, because the narrow rule is not inflexible, but is a rule in respect of which integrity for the legal system needs to be weighed heavily in the balance, Gray was, in our submission, correctly decided. The third criticism is that the reasoning in Gray is based upon incorrect assumptions about the statutory basis for the reasons behind the sentencing. And Mr. Bowen took you to paragraph 41 in the speech of Lord Hoffman. This is a red herring. The reason it's a red herring is because, in fact, Lord Hoffman's understanding of the position in criminal law was not part of the ratio in the case. And we can see that from, again, Lord Rogers' speech. I should say that the court and Mr. Bowen have had a considerable debate and argument about some of the sections of the Mental Health Act, in particular, section 45A. We say that that's really not very much to the point, because although Lord Hoffman commented on the purpose of the sentence, Lord Roger didn't approach the case in the same way. And if one looks, actually the easiest way of looking at this is by looking at what Mr. Justice Jay said at page 214 of the bundle, 214, which should be paragraph 46 in Mr. Justice Gray's judgment. Where Mr. Justice Jay said Lord Hoffman didn't comment on paragraph 15 of Lord Phillips' opinion. He didn't address earlier Court of Appeal authority, which suggested that hospital orders do not contain a penal element. Mr. Bowen submitted that that omission led him into error, which is a similar submission to the one he's made to this court. He says that's to be reserved for another occasion, and Mr. Bowen is now attending that occasion. But he then says, halfway down the paragraph, in any event, I must point out that Lord Roger came to the same conclusion without perpetrating this alleged solecism, from which it may be concluded that Lord Hoffman's specific comment about hospital orders was probably obiter. I think the real point which should be drawn from paragraph 41 of Lord Hoffman's opinion is that gradations of personal responsibility are irrelevant, and all that needs to be said is that the claimant's responsibility was diminished. So what Mr. Justice Gray is there saying, in my submission respectfully correctly, is that Lord Hoffman's understanding of the purpose of the various dispositions was neither here nor there. And what really mattered, as I will develop in a moment, is the question of whether the narrow and wide rules were based on considerations of inconsistency and incoherence. And put another way, clear that neither the narrow nor the wide rule depend upon the purpose of the sentence. That's not really what they're looking at. They're really looking at the underlying policy of the need to avoid inconsistency. The fourth criticism made of the narrow rule, or rather of Gray and in relation to the narrow rule, is that it imports an outmoded, discredited criminal test for responsibility into the civil law. There's a short and a long answer to this point. The short answer, I'm afraid I'm going to give you both. The short answer is that Gray does not import any criminal law concepts at all. The longer answer relates to the two manifestations of the appellant's argument. The first is that it's said by the appellant that Gray means that anyone with a criminal conviction is refused recovery. That is said at paragraph 38, page 79 in the Appellant's case. That is wrong, as the criminal justice example I referred to earlier shows. The majority would not necessarily have allowed the illegality defence to be deployed in answer to a claim by someone who had been convicted of a relatively minor offence. The second and perhaps bigger manifestation of the appellant's argument is that it suggested that the unsatisfactory law on insanity will be imported if Gray stands. That appears in the appellant's case. One finds those submissions at around pages 81 and 82. We say that is also wrong because Gray did not say, and forgive me for using this expression, but it's shorthand, Gray did not say that an insane claimant would or would not be able to recover. In fact, Lord Hoffman left that point expressly open in Gray. And if one goes to page 739 to paragraph 2 of the speech of Lord Hoffman, which I don't think we have looked at, paragraph 42, where Lord Hoffman referred to the Hunter and President case, the Australian case, an important case, and having dealt in the first 6 or so lines of paragraph 42, said this: there are dicta, for example, in the passage I've quoted from Clunis, which suggests that the rule does not apply when the plaintiff by reason of insanity is not responsible for his actions. But the majority regarded compensation even in such a case as contrary to public policy. Judge of Appeal Scheller made the pertinent observation that if the rule did not apply and the plaintiff had killed the negligent psychiatrist who discharged him, the latter's estate would not have been able to pay the plaintiff compensation for his consequent detention. This case, which Judge of Appeal Scheller described as unusual if not unique, raises an interesting question about the limits of the rule, which it is not necessary to decide for the purposes of this appeal. So Lord Hoffman left open the case of the insane claimant, and we submit that the question of insanity doesn't arise on the facts of the instant case. It didn't arise for decision in Clunis, it didn't arise for decision in Gray, and so anything said by this court on that topic would necessarily be obiter because it doesn't arise in this case either. And we do submit, and Lord Lloyd-Jones is better placed than I to have the detail of the concerns about insanity in the forefront. But we do submit that in an inquiry in this civil claim into the merits of a contentious criminal law concept like insanity risks entering an area of debate which is perhaps better left to a criminal case. But if it arises, and if the court feels that it is necessary to hear submission on this, on the question of what should happen in cases involving defendants who have been found not guilty by reason of insanity, we submit that whether a claimant in a civil claim could succeed in recovering damages would depend on the facts of the case, including the seriousness of the offence, and the extent to which damages were claimed within the wider or the narrow rule in Gray. So, for example, in a case in which the claimant had killed another, was found not guilty by reason of insanity, but was claiming damages for loss of liberty during detention under section 37 and 41 of the Mental Health Act, we would submit there would be a strong argument based on consistency that that loss should not found recovery, because it would be giving with the right hand what had been taken away by the left. On the other hand, in a case where a claimant might have committed a minor offence of criminal damage and was found not guilty by reason of insanity, the illegality defence probably wouldn't succeed. Sorry, on the authority of Gray, the illegality defence probably wouldn't succeed. And we do say that there is a danger of creating a bright line in homicide cases between claimants who've been found not guilty by reason of insanity and those who've been convicted of manslaughter by reason of diminished responsibility. And there are two potentially unfortunate consequences of that bright line. The first is, and this tendency has already emerged, that there will then be an incentive to challenge the finding of the criminal court in manslaughter cases to say, for example, well, I'm not sure my manslaughter conviction was right, and really I should have been found not guilty by reason of insanity. And that is not a fanciful suggestion, because indeed it has already been made in a case that has been pleaded. If one looks at page 529, you should find some particulars of claim in another case. I'm not going to name the claimant unless the court wishes me to. It's a case at page 529 against the Merseycare NHS Trust. Does my lord have that? Yes. You'll see the particulars of claim, paragraph 2, obviously a different case. This is a case where the claimant killed his father and his mother. That's clear from paragraph 2. And then if we go on in the bundle to paragraph to see the disposition of the criminal court, paragraph 31 at page 535. Claimant was charged with murder. Medical evidence was obtained and the prosecution agreed to a plea of manslaughter by reason of diminished responsibility. So that bears certain similarities with the instant case. Then if one then goes on to page 540 in the pleading, which is at paragraph 39, or contains paragraph 39, where this is said, insofar as the defendant seeks to rely upon a plea of illegality, the claimant will aver he was not in law significantly responsible for the killing of his parents, or in the alternative, he suffered from a disease of the mind and did not know the nature and quality of his act, nor did he realize that what he was doing was wrong. So here we have a case, in fact, pleaded by my learned friend, in which the claimant is saying, well, I may wish to challenge the diminished responsibility plea. I may instead wish to say I was insane, and therefore I would, on that premise, be able to recover. So if there is a bright line, we may well end up in a situation where claimants will be encouraged to seek to undermine the finding of the criminal court. And there's another possible outcome of a bright line position on insanity, and that is, and I don't have a case to place before you, so this is simply assertion on my part, but it may well be that defendants in criminal trials will now be encouraged to plead insanity in order to maintain a possible claim for damages in a later civil trial. So we do respectfully suggest that it would not be a good idea to have a bright line between insanity and manslaughter by reason of diminished responsibility. My lord, I see the time. I had understood we would stop at 4 o'clock.
Yes.
It's just before 4 o'clock on my watch.
Well, if you've reached a convenient point in your submissions, Mr. Will, then we can adjourn now.
I'm very sorry, I didn't hear that, my lord.
I'm sorry. I was saying that if we have reached a convenient point in your submissions, then we can adjourn that for the day.
We have reached a convenient point.
Very well, then. We'll adjourn now and resume at 10:30 tomorrow morning.